My lord, kindly see the green one, my lord, first. In 1981, an act to establish and incorporate a teaching, established and is deleted. My lord, with limited experience, my lord, I have come to know about such an amendment for the first time, where the preamble is amended, that it was not established. The historical fact is changed by making an amendment after about 60 years. And incorporation continues. So incorporation is also establishment. They possibly forgot, my lord, that established and incorporated. Now, please, my lord, see
No,
rest of that.
there may be an alternate reading also, which is that the amendment to the preamble is to bring the preamble in conformity with a historical fact. And in that sense, it is
Historical
declarative.
fact, my lord, cannot be changed, my lord, by.
They're not changing a historical fact. They're changing the provision of an act which was inconsistent with the historical fact. So as to bring it in conformity with the historical fact. I mean, there's an alternate reading possible.
My lord, kindly appreciate.
One more thing. This is the amendment by the parliament.
Correct?
And is the government accepting the amendment or?
I am not.
How can you not accept it, accept an amendment by Parliament? Mr. Solicitor, Parliament is an eternal, indestructible body under the Indian Union.
Correct, my lord, and
And
continuing.
irrespective of which government represents the cause of the Union of
No,
India.
I am not saying.
Parliament's cause is eternal, indivisible, and indestructible. And I can't hear the government of India to say that an amendment which Parliament made is something I don't stand by. You have to stand by this amendment.
Allow me to answer that, my lord.
You have an option. You go
Allow
through
me
the
to
amending.
answer.
You have an option. Go through the amending route and change the amending act
Allow me
again.
to answer that
That's
question.
ultimate power.
My lord, allow me to answer that question. My lord, I am not arguing a matter of A versus B. I am before a 7-judge constitution bench answering constitutional questions. That is number one. Number two, the amendment in question was subjected to challenge before the High Court, and there is a judgment declaring that it is unconstitutional for ABCD grounds. And as a law officer, it is my right as well as my lord, entitlement and duty to say that this view appears to be correct. And third,
Mr. Solicitor, this will be radical, because a law officer will be then telling us that I don't abide by what Parliament has done.
my lord, in that case,
You have to stand by what Parliament has done, but Parliament is supreme. Parliament is undoubtedly supreme in its lawmaking function. Parliament can always amend a statute. In which case, the law officer can say, "Well, I have an amended statute now, which I am going to place
your
before you."
lordships expect.
Can we hear any organ of the union government to say that, notwithstanding a parliamentary amendment, I don't accept this amendment?
Lord, I am supporting the judgment. Lord, would your lordships, my
In
lord,
that sense, Parliament.
please allow me to answer this.
Parliament is, that's why I said, Parliament is an eternal, indivisible, and an indestructible entity under the democracy.
No, I am not disputing that, but my lord, would you? I am posing a question to myself.
How can you
Would
say,
I-
look, I don't accept the validity of an amendment?
Hmm?
Or I don't
Lord,
accept, I
during
don't accept that there was a ground for
Can
this
I
amendment.
answer? My lord? Yeah, it's more, my lord, one-sided therefore, my lord. Can I answer that? Would a law officer be expected to say that whatever amendments were made in the Constitution of India during emergency were true only because they were made by the Parliament? Here, I have a judgment of the Supreme.
But Mr.
Allow me
Solicitor,
to complete.
that's why the 44th
I
amendment
will not
came
raise
in.
that point, my lord.
That's why the 44th amendment.
Let others
came in.
argue, my lord. If that is so, my lord, I will not raise that.
If the 44th
I'm
amendment
not-
came in only for that. The 44th amendment came to redress the evils which were perpetrated in the name of a constitutional
Who will
amendment.
decide, my lord, that these are evils being perpetrated?
Obviously, exactly. You prove my point. The power to decide that is in the elected body of the people, which is Parliament.
My lord, there is
Parliament can always say that what we did during the emergency was wrong, and we are rectifying it by
Lord,
the 44th
not
amendment.
after it is set aside by the division bench of a high court, my lord, and therefore it is not on the statute book. And when I am not in A versus B situation, I am in a constitution bench answering a legal proposition, whether such a thing can be done or not. And if I do not do, and there is an affidavit filed by the government, it's not my stand, it could have been my stand also. But if I cannot argue, my lord, that this amendment could not have been made, I will have to support, any law officer will have to support every amendment made during emergency, irrespective of, my lord, whether it is my view or anybody else's view that this was to remove some anomalies or some bad things happening to the citizens of India. I'm sorry, please don't make it a political thing. Please don't do this. Then don't interrupt. Then don't do it. Then don't. You said don't. I don't want to interrupt, and then you interrupt.
Ability in court, please.
My lord, I'm sorry, my lord. Your lordships would come in. Your lordships would come in.
Let's not,
Your lordships would come in, my lord.
Let's 1 second.
No, my lord. Here.
1 second, Mr. Let's not allow the pristine character of the dialogue to degenerate.
Yes, my lord. This is unacceptable.
1 second. We give you 30 seconds to make a point of law, not on personally on the Solicitor General. Let's keep out personal. Yes,
I was
30
in court
seconds.
on the day when the emergency argument was. I was only going to make a historical reference, Mullah. I was sitting in court when the Attorney General of India, Nirande, was standing here and arguing that what has been done is right. I defend the emergency provision. Why? Because he could not say otherwise. It's only that I'm saying. But I was not going to say anything against him.
Yes.
I don't know why. But
no, my lord, you did say something. You used an uncivilized word which is not used in the court, and you generally do not use. Maybe infected as of now, but my lord, I'll say, your lordship, the distinction is Nirende was not, my lord, in a situation where one High Court had struck it down and the provision was not on the statute book.
Yes, the
Here,
Madhya Pradesh High Court had struck it down.
9 high courts.
Yes. What do you?
there were other High Courts which have upheld, and there is all your lordships are aware, Mr. Nirende told the court that if somebody is hanged, can we not do anything? Yes, he said, yes, we cannot do anything. It was not to defend it. It was to instigate the judges that please interfere. This is the position. Lord, everyone knows, my lord, there are two versions. When Mr. Nirende, the learned Attorney General, then told the court, when the court asked, do we not protect Article 21 if somebody is being hanged or his personal liberty is deprived? He said, yes, you cannot do it. It was not to defend the act. It was to instigate the court that this is the position. Please interfere.
Mr. Solicitor General, let's come back to the point. Your
Yes.
argument is that 1981 amendment, you need not to comment for the simple reason that by virtue of a judicial verdict, this provision has been erased from the statute book. Correct? That is what you want.
It doesn't exist as of now. I leave it at that, my lord. I will not, my lord, be uncivilized in my lord arguments. Now, my lord, please come to Mr. Sibal is generally not, my lord, but then, my lord, please see, my lord, 51 amendment first. My lord, 51 amendment is at page, my lord, section 8, my lord, please see section 8. It is made, my lord, this is post-constitution. The university shall, subject to the provision of this act and the ordinances, be open.
Section 8.
8. Read is 51 amendment, my lord. The university shall, subject to the provision of this act and the ordinances, be open to persons of either sex and whatever race, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle him to be admitted therein as a teacher or student, or to hold any office therein, or to graduate thereat, or to enjoy or exercise any privilege thereof, except in respect of any particular benefaction accepted by the university, where such test is made a condition thereof by any testamentary or other so and so, so and so. Now, my lord, please see
Provided that nothing in this section shall be deemed to prevent a religious instruction being given in a manner prescribed.
Yes, my lord.
By the
To prevent religious instruction being given in the manner prescribed by the ordinances to those who have consented. My lord, this is 28.
Yes.
Article 20.
Just now, and now come to 28, Article 28. Just have.
28, my lord, yes.
23.
But, my lord, I must tell your lordships, this is not under challenge now. But this was, I'm just saying, this was to bring it in conformity with the constitution.
Just let's have a look at 28.
28, my lord. No religious instruction shall be provided. No religious instruction shall be provided in any educational institution wholly maintained out of the state funds.
Now, in 1951, this was a religious, this institution was maintained wholly by state funds.
May not be done, may not be wholly.
No, wholly we'll have to exclude small little fees, etc. But it was,
Otherwise, yes.
it was wholly.
Yes.
Yes, in fact, it is your argument that
Yes,
it was
yes.
wholly.
They were having some minor.
So there is a bar on providing religious instructions in institutions wholly maintained by state fund. Now,
Correct.
2.
Nothing in clause 1 shall apply to an educational institution which is administered by the state but has been established under any endowment or trust which requires that religious instruction shall be imparted in such institution.
So the exception carved out
Yes, this
where
is,
it is administered by the state, but the establishment is by the religious institute. It's a trust or endowment which is established. There, the religious instruction can be given.
Yes.
Now read 3.
no person attending any educational institution recognized by the state or receiving aid out of the state funds shall be required to take part in any religious instruction that may be imparted in such institution or to attend any religious worship that may be conducted in such institution or in any premises attached thereto, unless such person or if such person is a minor, his guardian has given his consent thereto.